my clock says 12:15. Why don't we start by just going around and each location, if each location could let me know if you hear us and see us and if everything's okay. And I see the Gustavus says yes.
Yes.
I can't actually see where all the different locations are. It popped up with the names, but then the names disappeared. So if folks just want to take a turn, and I know we saw Haynes.
Cooper Landing can see and hear.
Okay.
Dillingham can hear you.
Great.
Craig can see and hear you.
Okay. Well, I'm expecting some more folks to join us, but why don't we go on ahead and get started? Because there's got to be some benefit to being on time, right?
Definitely.
So I was a little worried about having a big group, but it looks like it's not as overwhelmingly big as I had worried about. So I don't want to go around and do individual introductions for each person, but I will say that if you have questions or comments as I go through the presentation, please feel free to go on ahead and jump right in and ask the questions or make your comments. A lot of what I'm hoping with in this presentation is not only to share the information that I've found and that we, about how we deal with confidentiality here at the State Library, but also to get input from people in other libraries around the state too. And I think that can be really valuable for us and really valuable for each of you, because you probably have more similar circumstances than what we have here exactly at the State Library. I do need to start out by saying that I am not a lawyer, and none of what I'm saying here should be interpreted as legal advice, and I know that sounds all like legal speak, but just want to make sure to get it out there. What I'm trying to do is to show a little bit about the research that I did in developing our own confidentiality policy here at the State Library, and then go through that policy and some of our training materials that we use in-house for staff. Hopefully that information will be helpful for you folks out there as well, but it's just a training thing, it's not legal advice. And I probably should also say that I'm Freya Anderson, and I'm the head of information services here at the State Library, and that's the section that is probably closest to a public library. We have public internet computers, we have people come in and read books and magazines and newspapers. We also, this section manages the state depository system, collecting state documents and getting those out to libraries around the state. And we also serve state employees, getting them the information that they need in order to best serve Alaskans. So without further ado, with further ado, there was one more thing I wanted to mention before getting into the presentation. If you would like a copy of the presentation and links and a few copies of the resources that we have here at the State Library, please go on ahead and email me. My email address is on the screen, and I would be happy to send that information out to you. I don't want to spam people though, so I won't send it out unless I get a request. Looks like we've gotten some more libraries in. If you haven't introduced yourself, could you let us know what library you're from?
Hi, my name's Katie. I'm from the Palmer Library.
Palmer, great. Did I see we got Anchorage? Maybe not. Well, let's keep going. Great to have you.
Thank you.
So I just have one slide here about privacy. Privacy and confidentiality are often used, those terms are often used interchangeably, and they're very similar, and so I think it's often justified for them to be used interchangeably, but they're a little bit different. And commonly, privacy is considered the right to be left alone. Privacy is very important to us, as well as confidentiality to libraries. In my mind, when I'm thinking about privacy as opposed to confidentiality, I think of privacy often in my speech instead of in written documents. So if I'm talking to a patron and we're going through a reference interview or talking about their personal account, but talking about it, of course, personnel issues and policy issues and anything to do with anybody who's underage, those are topics where I try to really consider where I am when I'm talking, and I tend to have a loudish voice, so I try to moderate that as I can. Sometimes that's a problem because, say, if you're talking with somebody who may be hard of hearing and you may need to speak up, and then that might be an occasion where thinking about where you are when you're talking can be helpful. I know that some of our libraries are pretty small, and the library here at the State Library is not a big facility, but sometimes we can go off to a corner or to a little bit quieter area in terms of how many people are around to have that discussion. And I just wanted to point out the Oxford Companion to American Law has a really nice overview of privacy at this link on the screen. And this is a resource that is available to all of us through the digital pipeline. Always have to plug that. Oxford Premium Reference. So use it. Confidentiality is actually protected under state law. The law is really short, so I'm actually just going to read the whole thing. It's Alaska Statutes 40.25.140. Section A says, except as provided in B of this section, the names, addresses, or other personal identifying information of people who have used materials made available to the public by a library shall be kept confidential except upon court order and are not subject to inspection under AS 40.25.110 or 40.25.120, and I just put in a little note that those are Alaska's public records laws. This section applies to libraries operated by the state, a municipality, or a public school, including the University of Alaska. And then it mentions, except as provided in Part B, which says records of a public elementary or secondary school library identifying a minor child shall be made available on request to a parent or guardian of that child. So this is pretty specific and doesn't allow a lot of wiggle room. It's analogous, I think, to some of the protections provided to other special areas such as healthcare or the press. And there's a long tradition of legal protection for these areas. It covers patron information, patron records, personally identifying information, and because there is an exception for minors for school libraries, I think that actually strengthens the lack of that exception for other libraries. It's very clear that the writers of this intended that exception to be only for school libraries, and that in public libraries, minors' personal information is still protected. I also popped on here the Code of Ethics of the American Library Association, not the whole code, but the section related to privacy and confidentiality. That's section 3. It says, we protect each user's right to privacy and confidentiality with respect to information sought or received and resources consulted, borrowed, acquired, or transmitted. That, of course, does not have the force of law, but it's, I think, an important thing for us as librarians to keep in mind. So that's what we're supposed to do. Now, how do we do it? There's a really great resource on WebJunction. I don't know if you're familiar with WebJunction, but it's got all sorts of great information for libraries. And they have a nice document on a checklist of best practices, which I borrowed from liberally for this presentation. They recommend conducting a privacy or confidentiality audit, gathering information about where you collect people's personal information. There's actually, I have a link later on in this presentation that will walk you through doing a privacy audit, helping you understand all the different places to look for that information. Once you found where you do keep the information, you may want to make changes. We did a privacy audit here at the State Library a few years ago, and we actually cut back the information that we were keeping. We thought we were doing a good job already, but we managed to cut back other information that we determined we didn't need to keep as long as we currently did. And those changes were mostly for through interlibrary loan. But we looked at a lot of different areas. You want to be sure to gather only the information that you need and keep it for only as long as you need it. So for that interlibrary loan example, we need to gather information about a patron in order to fulfill their request, or we don't know who to give that material to when it comes in. However, once a photocopy has come in or a book has been returned, we don't need to keep that personal information anymore. So we need to keep the information about the requests for photocopies for copyright purposes for 3 years, but we actually cut off the information about the patron and just keep the request information, not the personal information, once that request is completed. Consider restricting access to patron information so that only staff who need it have access. That's sometimes difficult, especially if you have a small staff. Everybody's probably doing everything, and so you may need to have everybody have access. But try to do that in a mindful way. You know, if somebody doesn't need access to something, then try not to give it to them. In larger libraries, oftentimes management may not need to have access. Maybe only the line staff need to. In interlibrary loan, that's my background, and so that's near and dear to my heart. One of the things that that came up that I think that we have actually started to make some changes, but we haven't fully implemented, is that you don't necessarily need to put patron information on the information you send out in a request to another library. Maybe you can put some sort of internal code so that the people at the lending library don't necessarily have the information about your patrons. You need that information in order to communicate with your patrons and provide that material, but they don't necessarily. Going on, it's really important to have a privacy or confidentiality policy. We'll go over the state library's policy. There are also a lot of other sample policies available on WebJunction, and there's some great information available through ALA as well. And then regularly train your staff and others on policies. And with that, consider covering the actual policy in depth, but also what to do in specific circumstances, who somebody can contact and who they maybe shouldn't contact. Then on the policy itself, consider especially what you want to incorporate in terms of, are there circumstances where you might allow for implied consent? And are there exceptions to your policy, and what specifically are those exceptions? I'm going to pop over now from the presentation and, oops, I'm going to try to get to the right one, but apparently I'm going to go to every other one first. So here we have the confidentiality policy for the state library, and I'm going to see if I can make this bigger. When I was looking at it earlier, it looked bigger on the screen to me, but now that it's only taking up part of my screen, it looks smaller. So I don't know, is that big enough that you folks out there can see it? Maybe wave if you can see it. So. Okay.
It's pixelating though.
Is it? Okay. Well, I'll try not to move around on it too much. And this is also part of what I can send out to anybody who requests the information. So don't worry too much about reading it straight through at this point, because I can provide the actual file to you. Basically, though, we affirm that we that we follow state law, and we actually incorporate state law into our policy. And then we emphasize that we give detail about who we won't give information to without a court order. The people we include are people who sometimes expect to have that information provided to them, including spouses, parents, guardians, and uniformed law enforcement officers without a court order. We do incorporate implied consent in our policy. I think that having this specifically in the policy helps us because so many of our patrons expect this service from us. So we specifically say that we will check out materials on hold, renew items, or pay fines. We will let a person do that for somebody else if they have the person's library card, if they know the specific titles of the items to be picked up, or if they are authorized by telephone at the time of checkout or have a signed note from the person whose account it is. We get a lot of people who are picking up materials for other family members, and I'm sure you guys get that as well. And this allows that while maintaining limits on it. So we will allow someone to check out or renew or pay fines, but we won't allow them to get a list of the materials that are currently checked out by that patron, for example. We also serve as sort of, in addition to our public library functions, we also serve as a special library for state employees, and we also have exceptions for what we call agency cards. State employees, including legislators, can check out materials on an agency card and then that they need for further work. In that case, if someone, say, leaves state employment and the material is still checked out, we may, after trying to contact the person who originally checked it out, we may contact other people in that agency to try to get that material back. We do our best to maintain confidentiality and privacy, but we don't believe that there is an expectation of privacy in that work environment. However, any executive branch personnel or legislators, anybody who's eligible for this service is also eligible to get a personal card. So if they have materials that they want full confidentiality protections with, they are always welcome to get a personal card and to check materials out with that card. If they check it out personally to themselves instead of to their agency, then they have all the regular confidentiality protections. None of these exceptions that we list here are would apply. And then, of course, if there's a court order, we go into, in our training, we go into a lot more detail about this, but of course, if there is a court order, we will comply with that. Are there any questions so far or any comments so far about our policy or other policies? Okay, I'm going to try to get over to the, I'm going to go through everything in order to get through to the one that I want. There we go. Let me make this bigger as well. So this is our training that we use in-house for our staff with this handy-dandy title, What to Do If Law Enforcement Comes In. We try to do this to update the training regularly and to present it to staff frequently. Probably we don't do it quite as frequently as we should. I know that libraries all over are dealing with trying to do too many things in too little time, and things often get pushed out a little bit. But it is important to go over this with new staff and to go over it periodically with regular staff. We go through what people should do in specific circumstances. When can they provide information that might identify what somebody, information about somebody or what they've read? Never do we give information out without any identification other than to the individual in question. If they have identification that appears valid, generally we refer them to our director. So most staff still don't give out this information. There are circumstances where you might need to give out information but not be able to refer them to, but not be able to share the information with other people on staff. If there's a gag order, for example. According to the American Library Association, however, their legal advice is that you can still contact your library director if that's not you. And what I've put in here is it actually says EED attorney because that's our parent department, but you can contact an attorney. When you're providing information, don't volunteer any extra, and certainly provide who you are and your address. There are different kinds of court orders that might be presented, and we actually have I have some examples here. They're available through the ALA website. If you get a subpoena, you don't have to give them anything at all right then. Simply take the subpoena, sign for it if you need to, thank the officer, and then give it to your director if that's not you. But don't offer any information or provide any documents at this point. At that point, you probably would want to contact a lawyer if you are the director, and ensure that it's a valid subpoena, and what information exactly that you need to provide. If they present a search warrant, they may be able to take that information right away. You still can ask to have time to go get a director and or a lawyer, but they may not want to wait. And if they don't, then you shouldn't stop them in this case if they have a search warrant. But do look at the search warrant. Make sure it's from an Alaskan court or for a federal court based in Alaska. Make sure that it's current and not expired. If you're not sure that it's valid, call the court that issued it to confirm that it's a valid search warrant. And look very closely at what it allows to be searched or what records should be produced, and really do your very best to only to provide what is specifically requested. Any other information should be kept private, and if this means that you're cooperating, then you should cooperate and go on ahead and pull the records for a specific person rather than providing them direct access to your catalog. Keep copies if you can. Ideally, provide the copies to the law enforcement and keep the originals, but if you can't do that, then at least keep copies for the library. Don't volunteer any additional information, and keep notes on everything that you provide, what they say, what they do, what you say, what you do. Keep as complete notes as you can, and then contact either the director if that's not you, or a lawyer afterwards. Some resources include a gag order, and in that case you wouldn't be able to speak about the request to anyone except for the director, an attorney, and the staff necessary to produce the records. For example, here at the State Library, our catalog is administered by somebody at the public library, Kate Bernstead, and Daniel is our local contact for that catalog. If anybody else asks you about the situation, you should have very clear who is allowed to speak to other people. Generally, that would be the director, and probably not anybody else. Never discuss anything related to confidentiality requests with anybody else unless you're authorized to do so. Here at the State Library, only the director is authorized to do so, unless we're specifically authorized to talk about a specific situation. We actually include information on who specifically we should contact in specific cases. And we talk about not keeping information that we don't need. It's tempting with information storage being so inexpensive now, and where everybody has huge access on on the cloud, if not on your own computers, to keep every single email and all of your paperwork going back. It's really tempting, and there are times when it actually is helpful. There are times when I've gone back and searched in my email and I found something that turned out to be helpful. But you probably don't want to keep that information any longer than necessary anyway, just for the confidentiality. If you don't have the information, you can't provide the information. Now, you need to make those decisions about how long is necessary, and depending on the information that in question and your particular circumstances, that length of period might vary. It might be that as soon as a loan is completed, the information goes away. It could be with a reference request that you often get follow-up questions, and so maybe you decide that you need to keep an original reference request for another week in case you get follow-up questions. But whatever you decide, you want to err on the side of short. Keep as little information as you can, and keep it for as short a period of time as you can. I have a couple more slides, but after this, the slides are pretty much just talking about additional resources, and there we go. Again, I can send these out to anybody who requests them. There's some helpful resources there. I'd really love to hear, though, from other libraries out there. In particular, what I'm really interested in, I'm interested in all of your comments or questions related to confidentiality and privacy, but in particular, what exceptions do you have in your policies where do you have implied consent at all, and what do you require in order to allow for implied consent? Somebody speak up.
Okay, this is Haynes. We have a lot of people who live out the highway, and they will send their friends to pick up their books for them who also live out the highway. And we kind of know who goes with who, so it's not written anywhere, but we'll allow them, because they'll come in and say, 20 is expecting, and they'll say what. But it isn't written, but we obviously need to do that. And then sometimes the spouse will know exactly what the other spouse, in fact, they're both watching the movies together.
Right.
Yeah. So that, and then also when a book goes way overdue and missing, and a parent is trying to look for it for the kid, we'll give them the title of the book.
So the first two make sense to me, because it's clear that somebody is sending somebody in to pick something up for them, and it may be worth actually writing that down into your policy, so that it's clear and nobody can come back and say, wait, I didn't say that. Well, you could say, well, in these are the circumstances that we said that we would assume that there was consent. I wonder with the kids, with the overdue books, I completely understand, but I wonder if you have any justification for that related to the law, or if it's just something that is expedient.
Well, it was quite a few years ago that this had actually come up, the discussion of whether yes or no to that, and whether we should answer that question. Mm-hmm. And this was back when Ann Meyerman was the director, and we were in our old library, so a while ago. And it had come from someone in the state library was talking about, well, it's kind of a gray area, you've gotten to the point where the person who had the book out, has taken the book out and has kind of broken a contract, as it were, sort of a, unwritten, well, it's a written contract, actually, they'll return the books, but, and then somehow that put us in a gray area that kind of made it, I don't know.
Yeah.
Yeah. And so that, yeah, you could do it. That was just something we got from somebody, advice we got when it was still functioning under it.
I think that's really indicative. I think there's been different, and I think interpretations have kind of changed over time. And, I'm not a lawyer, and so I can't do the legal interpretation either. My personal interpretation and the way we've interpreted it here at the state library is that we couldn't provide that information to a parent. We could provide that information to the child, who could provide that information to the parent. But not directly. But again, this isn't saying what you should do. It's just saying how we've interpreted it for our library.
In Cooper Landing, unless a child is 16 or older, we require parental permission for them to get a library card. Parental consent, I suppose. And therefore, it seems to me that those parents are also taking on responsibility for what their children check out. We're dealing with a community where most of our children are under 12 years old. Anyway, so, when we have that kind of an issue when kids check out books, then we call the parent and say, your child has so many books checked out, not necessarily the titles, unless they become grossly overdue.
Well, you bring up a really good point, and I think it's one that is often frustrating for parents. We will tell parents when there are overdue books, and we will tell them what the fines are. That's not that goes more to the responsibility that they have taken. However, and we have gotten flack about this, but the way we've interpreted the law for us is that, and I'll go back to the law here, is that we can't actually provide the personally identifying information. We consider the books to be part of that. So you could kind of read this, you can read this different ways, and as you read through this, I can see different interpretations. And there certainly is frustration on parents' part when you tell them that yes, they're responsible for the fines, and no, you can't tell them what books those fines are for.
That'd be kind of different. You gotta help the kid find the fine.
But you can tell if the child doesn't remember, you can certainly remind them it's their account, and then the child can tell the parent. The other thing to keep in mind is that I think it's really important to be upfront about this and to have this information available, which, we've all been open for goodly periods of time, and we all have people signed up already, and maybe we didn't make this information necessarily available to them in the past. Maybe we did. But I think making this information available when a parent signs for a child who is under 16 or whatever the policy is at your library, whenever a parent signs to take responsibility for that child's card, I think it's helpful to make sure they know what they're signing up for. And what we do tell parents is that if they really want to be aware of the titles that their children are checking out, they can check out those children's books on their own account, on the parent's account, which is of course not ideal either, but. So it looks like we have 5 more minutes scheduled. I would love to continue on this conversation, and I hope I'm not being too concrete in my in what I'm saying about how we do it, because I really do mean that, you know, each library has to make their own evaluations of the law and evaluations of your own specific circumstances and come up with your own policies. And what I'm talking about here is what we've come up with, not through library development, working with libraries around the state, but what we've come up with for our own library lending to people. And I think it's really important to read the statutes and to read the other resources available, and possibly check with a local attorney if that's appropriate for your library. But I don't mean to be saying you should do exactly what we do. Are there any other comments or questions out there? Palmer?
Hi, thank you. Can you hear me okay?
Yeah.
Okay. This isn't so much a policy question as something we've been delving into a bit more recently with one of our staff who takes issue with maybe racy material that our patrons look at on the internet and cries pornography pretty often. And we just feel a lot of confusion amongst staff and ourselves of what line we're supposed to walk with that issue.
That's a really tough issue, and I think that's more the privacy side than the confidentiality side. That's sort of where I draw those distinctions, and so I haven't really gone into that. That's part of why I didn't really go into that here. But I think that I think it's still a policy issue. It's just a different policy. So for our users, we do have public internet, and we have Wi-Fi, and we have a use policy for that public internet. And we have determined, as part of our use policy, that not only are certain uses are illegal. So when you're dealing with child pornography, of course, that would be an illegal use. But we've also determined that certain other uses are not acceptable. And part of that is because the state of Alaska is paying for our bandwidth, and we, our funding folks just really don't believe that the state of Alaska paying for certain uses is a good use of money. So our policy actually does disallow accessing other types of pornography in addition to what's actually illegal. And it also disallows gambling. We have a whole policy, and I can send that to you if you'd like to see that. Just email me. And but the specifics of what you choose to incorporate into that use policy really depend on your community, your library. And so those are decisions beyond the illegal parts that you need to make there on whether you'll allow it. And then if you allow it, then there's the, once you've come up with policy, then there's the whole determination of how you want to enforce